Hello everyone, welcome to Corporate Law Journal, a drive for sustainable corporate world. The vision behind this platform is to explore corporate literacy and impart legal education in simple and lucid manner. The topic for today's session is negotiation of contracts and finalizing of documents. The keynote speaker for today's session is Advocate Divya Malcolm. She specializes in real estate and has over 15 years of expertise in the sector. She has also worked on redevelopment of mill lands, slums, old and seized buildings, and cooperative housing societies. She was a partner at Kochhar Co and head real estate at its Mumbai office. She joined the bar in 2006 and topped the class in drafting. Today, she has her own practice in Mumbai, Gujarat and Daman. Do share your views in the comment section below. Do like it and share it, and do not forget to subscribe to our channel below and hit the bell icon for more updates. Thank you.
A very good afternoon to everybody. First of all, I would like to thank Shubham Jain and the Corporate Law Journal for giving me yet another opportunity on their platform. When Shubham and I were discussing possible topics for a 10-minute presentation, negotiation of contracts and finalization of documents came up as a natural choice. Shubham's logic was very simple. It is one thing you can't learn by opening a textbook. So, if you were to ask me what are the things in negotiation of contracts, I would say a cool temperament and understanding the requirements of the client. Why a cool temperament? Because you cannot go to the negotiating table with a prepared script. As advocates, we are required to think on our feet, and there are bound to be contentious issues in the simplest of negotiations. In order to resolve these contentious issues, we need to think of a new argument. We need to convince everybody, come up with solutions. And one of the best methods to make sure that the negotiations don't go off tangent is to park the contentious issues and take up all the contentious issues at the end towards the end. By that time, everybody has invested enough effort, time and money, and many a times things get sorted automatically. It is for this reason the right attitude towards any transaction is that of patience. Moving on to actual documents, well, the starting point of any negotiation is the term sheet or the letter of intent. And what is a term sheet and the letter of intent? It is nothing more than a mere handshake, a gentleman's word. So if a client requests you to negotiate a term sheet or a letter of intent, don't put spoilers such as a clause for specific performance. A term sheet typically captures the broad understanding of the parties, the commercial understanding of the parties, and it is for us advocates to make sure that eventually a legally firm document follows. Remember, as advocates, we are never expected to negotiate the commercial aspects of a transaction. So, it is not appreciated by anybody if the advocate starts talking about the purchase price, if the advocate starts talking about the adequacy of rentals, the security deposits, so on and so forth. But the real fun in the transaction starts the minute the exercise of due diligence, be it a simple titled due diligence in a real estate transaction or a more holistic legal due diligence as far as M&As are concerned. So the real fun starts once the due diligence exercise is initiated. And believe me, you will never come across a due diligence report where there are no red flag issues. It is for us advocates to suggest ways and methods of mitigating these red flag issues. Many a times the red flag issues are mitigated either by way of representations and warranties, or having some of them as conditions precedent. While negotiating representations and warranties, remember, a very high degree of evidence is required to prove misrepresentations, and a misrepresentation gives the contracting party a right to terminate the contract, to walk out of the contractual obligations. But an exit, walking out on any transaction, is an expensive proposition for everyone. It's not only the party who resigns the contract suffers. I mean, not only the party against whom the right of termination is exercised suffers, but also the party who invokes, who decides to terminate the contract, he too suffers. So, walking out of a contract is never a solution. Therefore, have enough cushioning in your documents. This may be by way of liquidated damages for delay in performance of an obligation. Insist on timelines. Don't keep all your obligations open-ended. One interesting thing that I have observed is that people often think that the word penalty is of greater deterrence value. The word penalty protects their client more than liquidated damages. Now, the word penalty may have a nice sting to it, but in fact, you would be doing your client a disfavor if you refer to what is genuinely liquidated damages as penalty. The rationale for this can be found in our Indian Contract Act. Remember, when as far as penalty is concerned, the court cannot immediately grant something which is termed as penalty. It is the maximum amount of damages that can be granted by any court of law. But if you have come to if you have come to a reasonable estimate of liquidated damages, then courts are quick to grant what is stated in the document as liquidated damages. The Specific Performance Act was overhauled in 2018. So, in view of the sweeping amendments made in the Specific Relief Act, you have to today be even more careful as far as your documentation is concerned, particularly as far as clauses pertaining to liquidated damages are concerned. So, another way in which we hedge our bets is by having indemnity clauses. Now, where clients, the spar over an indemnity clause is a typical indemnity clause has a lot of ambiguities. So, anybody would have reservations agreeing to indemnify the other party as far as business losses are concerned, as far as remote consequences are concerned. So the typical exclusions in an indemnity clause refer to business losses, refer to remote consequences, and often an indemnity is capped. The maximum amount that a person can seek by way of indemnity is capped at a certain comfort level of both the parties. But this is as far as typical clauses in any commercial transaction are concerned. It has been my experience that by the time all the parties traverse the entire document and reach the clauses pertaining to dispute resolution, everybody is exhausted, their attention span is over, and a very indifferent treatment is given to one of the most important clauses. There is a misconception that an arbitration clause is a panacea. It cures all ills. Remember, an arbitration clause is not applicable in all transactions. You wouldn't believe this, but I have even come across an arbitration clause in a will. I've come across arbitration clauses in a mortgage deed. I've come across arbitration clauses in a leave-in license agreement. Of course, the jury is still out as far as an arbitration clause in a lease agreement is concerned. But remember, in none of these instances is an arbitration clause applicable. And it is our duty as advocates to make sure that there are no legal infirmities in the document. When you decide on a dispute resolution clause, now remember there are transactions such as a loan of, this is particularly true of financial transactions. N number of, where a financial facility is availed by a borrower. N number of documents are executed by the borrower. Make sure that the dispute resolution clause in all the documents is uniform. Inconsistency and dispute resolution clauses leads to a lot of issues at the time of enforcement of the contract. And I had earlier given a presentation on the Indian Stamp Act. It's been my experience that people look up the Indian stamp or the Stamp Act right at the end of the transaction. I would personally advise everybody to look up the Stamp Act as soon as the transaction begins. That way, you can structure your entire transaction in a more tax efficient manner. Well, I hope, I think 10 minutes are up, and I wish everybody, especially Corporate Law Journal, all the very best. Hope to see you soon. Thank you so much. Goodbye.